Hello, NCA students. Today our topic is Indigenous People and the Law. To understand this topic, we must know about Canadian Constitution. For that, I just want to clarify some important points to know this whole concept. There is no single document we call as a Canadian Constitution. Okay, so then what thing we call as a Canadian Constitution? So for that, there is one document, British North America Act 1867 is a very important tool to understand Canadian Constitution. Actually, it was a basic point of origin of Canadian Constitution. It established federalism in Canada, and allocated power to federal parliament and provincial legislature. It recognized dominion of Canada. Basically, Canada was not a big country at that time. It was actually creation of united three British colonies of North America, and we already covered this in our previous video. Like there are these three provinces are just in east side of Canada. We can see New Brunswick, Nova Scotia, Labrador, and Newfoundland, Ontario, and Quebec. These are the basically three British colonies. We call the three British colonies means Ontario and Quebec was one part, and other two were different. So basically, British North America Act 1867 was the first act which established federalism, but it was passed by UK government because Canada was a colony of UK. So only this was passed by the Parliament of UK. No amendment possible by Canadian legislature or Canadian Parliament. It was made by UK only. All amendment till date 1982, when Canada got full freedom, 1867 was amended by many times, but it was amended by UK government itself for Canada, because Canada does not have a freedom at that time. He got freedom in 1982. So in 1982, what happened? It happened like 1867 British North America Act 1867 changes into Canada Act 1867. Only name was changed. And one Canada Act 1982 was made. It was made for certain purpose. From this act, whole the powers which was exercised by the UK in the previous time is now transferred to Canada. So Canada got freedom. Now this act giving power to Canada government to make their own law. So in Schedule B of this Canada Act, there was a Canadian Constitution 1982. Okay, so this was the primary act giving power to Canada government to make laws, and in Schedule B there was a Canada Constitution 1982, which has having a provisions of constitution, etc., and power, federalism, Aboriginals, Indigenous people like. So today's our topic is Indigenous People and the Law. So come into the history, some points are very necessary to know about these concepts. Like in Canada, begin with the slavery. There was a slavery in Canada before Columbus came into North America, and they called here people as a red Indian, because their skin was red at that time, and he was actually looking for India, but he could not find India, but he find America, and they called natives of the North America as a red Indians because of their skin color. So Canada began with slavery. British people came here. They slaved native of Canada. In 1790, legislative action in Upper Canada. Legislative action in Upper Canada. Upper Canada here means the Quebec part and Ontario part, north part of Ontario and north part of Quebec. Upper Canada. Legislative action in 1790 and judicial action in Lower Canada. Lower Canada here means Lower Quebec, Lower Ontario, Nova Scotia, New Brunswick, Prince Edward Island. Okay. So they by legislative action and they by judicial action remove slavery. Now slavery ends in Canada. Finally, in 1833, whole America and whole Canada recognized by British government that slavery finally abolished. Slavery finally abolished in Canada and America in 1833. But what about the status of natives of Canada at that time? They are red Indians. They are perceived and viewed not as a independent and sovereign people. Okay. They are a dependent group of, they are treated as a dependent group of a crown. Generally, they are subject in need of protection and civilization. So, for that purpose, during colonial period, we can see there was a isolation policy. Isolation policy has been predominant, leading to creation of reserves area of indigenous people. Actually, Canadian government believe at that time we have to be also isolate that community somewhere else because they are attackers. So isolation policy came into play at that time during the colonial period. So they are actually special disabled persons. They were attached their status like this is the reserve area in Canada. This is the other part of Canada. Other part. And this is reserve area. Reserve area means Aboriginal peoples are used to live here. So they are prevented from voting. They cannot vote. And secondly, they could not leave their reserve without permission. So they have attached with certain disabilities, like they cannot move freely in that area. So the first question which came into the mind of our students, whom we called as a Aboriginal or indigenous people. So in early times, everyone who followed the way of life as Aboriginal accepted as a Aboriginal. But in 1850, in Lower Canada here means which is densely populated at that time. like New Brunswick, Nova Scotia, Prince Edward Island, Lower Quebec, Lower Ontario part. In Lower Canada, bloodline requirement prescribed by that Lower Canada government. So they identified that who could occupy Aboriginal reserve land. But in the meantime, 1867, we can see British North America Act 1867 was passed, which created dominion status to the Canada. So after that, 1867 to 1982, this was the journey of laws made by UK government for the betterment of Aboriginal peoples, indigenous people, and for that purpose they are making amendment to this act timely. And for that we can see section 91 clause 24 of this act, which says who are Indians. They defined Indians actually. And for that purpose, we have to understand who are Indians. Indians here means red Indians, the natives of Canada and North America, whom Columbus in 1892 called as red Indians. So that is why this word is used in 1867 Act, Indians. Section 91 clause 24 defined about this. And by now we now in Canada Constitution 1982 come into play, and section 35 of this act recognize three group of Aboriginal. These three groups are basically, first are Indians. We already know who are Indians. Red Indians, Columbus called them in 1492 natives. And second is Inuits. These are basically Eskimos who lived in igloos. Igloos are small houses built from hard snow actually. They used to live in upper North Canada, where the temperature is very harsh, low temperature. So they used to live there. They are also native, but their skin and atmosphere and way of life is different than that of other Aboriginal peoples. And third one are Metis. Metis are those people who actually having a Aboriginal mother but French father, because we already know there was a French colony in Canada, and French people used to interact with the peoples, and they just started marrying with Aboriginal ladies, and they have a son or daughters who we may called them as a Metis. And thereafter we came to know who are Indians, who are Aboriginal peoples. Now 1982 Canadian Constitution Act came into force. Now special rights and titles are given to Aboriginal peoples under section 35 of Canadian Constitution Act. So what are their special rights and titles? What are the basic requirement for that? It is actually it's not a universal to all Aboriginal people. Their application is varying from one part to other part of the country, from one group to other group of the country. So federal government is competent to make law on that. Federal government determined Indian status, Aboriginal status under own rules. Parliament have a exclusive power to make rule and law with regard to Indians and land reserve for them. Land reserve for them. Now, Aboriginal people have a same right with other Canadians under Section 35, and moreover, in Canadian Constitution 1982, there was a part 1. Part 1 talk about charter rights. Charter rights, under charter rights, there is one section called Section 25, which also saves the rights titles of Aboriginal peoples. Canadian Act Section 35 also giving saving that rights, and charter rights Section 25 also saving that rights. There are two provisions which says that Aboriginals have to save and their land has to be saved. The Parliament have a exclusive power. No provincial government has a power to make law on that point. But there are certain laws provincial government can make law on that topics also. But it is depend upon their competency. Like they cannot make general law. So Aboriginal people cannot legally bargain. Aboriginal people cannot legally bargain to give up their rights. Like if Section 35 or 25 or even any section is giving some rights to Aboriginal people, they cannot give up that rights because it is a group rights. Community are exercising that rights. Individual cannot exercise. So we can see that their rights, their treaty rights, and their land alienate power, they cannot exercise indigenous people because it can be exercised only with the power given by the crown to them. So reserve land in favor of anyone other the crown because they can alienate to crown only for specific purpose if crown make a law on that point. So there is one act also which says regarding this, like Indian Act 1876. It is also important. The word Indian is using because they are called as a Red Indian and they are natives of Canada and North America. Aboriginal people's right to land, their right to land is a communal right. Like it means the right to land belong to group rather than the individual member of that group. No bargaining power to group. So actually bargaining power to group, but not bargaining power to a single individual. Aboriginal people have the right to use the land. They can use the land, but technically it was owned by crown. It was owned by crown. It is same like ancient Roman law, right to use land which is owned by another. The same provision we can see in our Indian law also, like which recognize the concept in limitation law and specific relief act. Adverse possession. The same law we can see in Indian Act 1876 with respect to Canada. So now land right of Aboriginal are largely recognized but undefined. So who can define it? Basically it depend upon legal definition given by Supreme Court time to time. So this is the actually history of this. But generally the word First Nation was used for indigenous people, for Aboriginal people. So we have to know about the history of the word First Nation. the concept in Canadian jurisprudence and legal history of First Nation. Actually it is a designated group, designated group, along with women, minorities, people with physical and mental disabilities. First, we called it a First Nation because at the time when 6 year war, 7 year war occurred between French and British in year 1756 to 1763. There are 7 native communities who helped France in that war, and they called themselves as a First Nation. That is why this name is always used in different acts, in different provision, in different regulation. That these communities are also called as a First Nation. These are actually 7 communities. It's a group of 7 communities. It is also part of Aboriginal. So basically, First Nation represent around 60% of Aboriginal population. 60% of Aboriginal population. And we can see that in 1787 to 1799, when French Revolution came, France was also considered as a First Nation. It was they were called as a First Nation. It was influenced by that 7 native communities. So this is the history of a First Nation world. Though First Nation communities basically now residing at Western provinces. So Western provinces here means Manitoba, Saskatchewan, Alberta, and some part of Ontario, British Columbia. These are the areas where First Nation communities, 7 communities are used to live. So their rights are dependent upon many things. Like it was recognized by judicial decisions. In order to be Aboriginal right, the activity which is into an issue must be an element of practice. It must be an element of a practice, custom, tradition. It was a integral part of their culture, claiming so that is why they are claiming their rights. First, identify the exact, if there is a question whether this right belongs to Aboriginals. So identify the nature of activity, and this activity claimed to be right must then go to determine whether the activity could be said to a defining feature of culture in question. From that, Supreme Court time to time recognized Aboriginal rights, from which there was some clashes between Crown and Aboriginal rights, because after industrialization, Crown want more and more land to build some houses, to build some infrastructure. For that purpose, they have to curtail their reserve areas. That is why there was a clashes between Aboriginal people and Crown. So to identify their rights, the Supreme Court timely giving some interpretation regarding their right to recognize their rights and curtailing the rights of the Crown. That is why Aboriginal rights are necessary to understand here what right we called as a Aboriginal right. There are some treaties which play a significant role to understand the title and right of indigenous people, Aboriginal peoples. Treaty generally refer to an agreement. It is an agreement between indigenous people and between Government of Canada, Government of Canada, Government of Provinces, and Government of Territories. These territories define right and obligation of respective parties and recognized, affirmed by Section 35 of Constitution Act 1982. These treaties are very important to enforce that treaty. Enforcement of these treaties are very important for federal government, for provincial government, because these treaties are recognized under Section 35 of Constitution Act 1982, and moreover it is also part of a United Nation Declaration, for which we can understand the rights of indigenous people, which Canada has committed to adopt. So these treaties are of two types. One is historical treaties, and second one is modern treaties. For knowing the historical treaties, we may understand the year 1701 to 1923. In these years, there are many treaties made by government with the indigenous people for understanding their behavior, to understanding their way of life. From that treaties, Crown got a land in exchange of a reserve and other benefit given to Aboriginal peoples. These are the actually agreements in form of treaties. In modern treaties, we can see it began with the year 1973 to till date. It was a modern treaties. Till date, 25 modern treaties have already been made through that agreement between indigenous people and Canadian government with regard to natural resources which are possessed by indigenous people. That is why they have to understand these treaties. So if we talk about these rights, indigenous rights, so there is one section which is very important to understand. Like if provincial government having one law which basically curtail the rights and titles of indigenous people, what will happen? So there are many case laws upon that. One is Sparrow case. It is very important case, in which case we can understand that Supreme Court of Canada recognize so what we called as a Aboriginal right, what we called as a title, as a Aboriginal title, and how we identify, how we separate them with other laws, and how we save that right and title for Aboriginal betterment of Aboriginal peoples. So it means the provincial government cannot curtail the rights and titles of the Aboriginal people. It is not so. Provincial law may infringe an Aboriginal and a treaty right, but there must be compelling and substantial objective behind it. What is substantial and comprehensively compelling objective? It is time to time described by Honorable Supreme Court of Canada. So this is all about the rights actually, and we came to know that there are two provisions, Section 35 of Canadian Constitution 1982 with regard to indigenous people, Section 25 of Charter Rights and section 91 clause 24 of Constitution Act 1867 is also talk about it. It gives the federal government power in order to protect and make law with regard to Indians and land reserved for Indians. So basically, this is the all about indigenous people. There are some rights, there are some titles, there are some treaties which recognize their nativeness of Canada. So there are actually 40% near about land only reserves for Aboriginal in throughout of Canada. And if government want to acquire that land, they have to go through some treaties and their home go through some titles. Federal government can make a law, but if they want to curtail that land, they have to give some benefits to them Aboriginal people. That is why their title, their right and their charter rights are covered under Constitution of Canada, charter rights, and even recognized by United Nations. That is all about it. Thank you so much. Goodbye.